Good evening. My name is Kimberly Williams, and I work in the Community Engagement and Division at the Michigan Department of Civil Rights, and I will be your moderator today. For full accessibility today, it is crucial that speakers first identify themselves by name before proceeding to speak and mute their microphones after they are done speaking. We have ASL interpreters on screen, and live card captioning is available by turning on your subtitles using the CC icon on the lower part of your screen. We will have a question and answer portion during today's session, and attendees can use the Q&A function on the lower part of the screen to type in questions for the panelists at any time. With that said, it is with great pleasure I welcome you to our 2024 MI, spelled M-I, Response to Hate virtual campaign forums. These series will feature a new installment of hate and bias awareness programming each month from now through September, when the campaign ends with our annual My Response to Hate conference. Right now, let's take a look at a PSA our team developed to capture the spirit of the My Response to Hate campaign.
Did you know that race is the #1 motivating factor for hate crimes in the United States?
Did you know that hate crimes against Asian Americans have increased by over 73% since 2019?
Did you know that there are state and federal laws that protect you against hate crimes and bias incidents?
The Michigan Department of Civil Rights and the Michigan Alliance Against Hate Crimes have launched the My Response to Hate campaign to inform Michiganders of hate crimes and bias incidents occurring in Michigan.
You can take action in your own way by showing love, not hate.
If you see something, say something.
Support victims. Report the incident.
Make a commitment.
My response to hate.
My response to hate.
My response to hate.
My response to hate is love.
Visit michigan.gov/MDCR for more information on hate crimes, bias incidents, and available resources.
This is Kimberly speaking. It is our hope that these forums provide you with information pertaining to hate and bias prevention that you can implement and use in your daily lives, at your place of work, in your schools, and in your community. Once again, it is with great pleasure that I welcome you to our March forum, spelled My MI Response to Hate. If you have missed any of our previous forums, which started in January of 2022, the series is available for viewing at your convenience on the Michigan Department of Civil Rights YouTube and Facebook platforms. You can learn more at michigan.gov/MDCR. Now I will introduce our first presenters. Dr. Donna Bell is owner and chief business consultant for Donna Bell LLC. The mission of Donna Bell LLC is to contribute to a more sustainable environment by working with companies on integrating and improving sustainable business strategies, practices, designs, and other solutions that address environmental and social challenges. Prior to starting her consulting firm, Dr. Bell was an executive president of production, creation, engineering, supply chain at Lordstown Motor Corporation, LMC, where she managed the development and execution of LMC vehicles, subsystems, hardware, software, and supply chain partnerships from concept to launch. For more than 30 years, Dr. Bell served in various leadership roles at Ford Motor Company. Dr. Bell earned a bachelor's degree of science in electrical engineering from Lawrence Technological University in Southfield. She earned 2 master's degrees and a PhD in industrial and systems engineering with a focus on the intersection of quality and innovation, all from Wayne State University in Detroit, Michigan. Dr. Bell is a Board of Trustee member at Lawrence Technological University and serves on the Academic Affairs Committee. She is also the chair of the College of Engineering Advisory Board. She is a board of director for the Torch of Wisdom Foundation in Southfield, Michigan. Dr. Bell was appointed by Governor Whitmer to co-chair the Black Leadership Advisory Council. She will also be joined by Kimberly Trent. Deputy Director for Prosperity at the Department of Labor and Economic Opportunity, better known as LEO. Kim Trent is charged with guiding and building support for efforts to boost the economic security of Michigan citizens through policy, strategic initiatives, programs, and partnership. Her leadership duties at LEO include serving as a key staffer to the Michigan Poverty Task Force. She leads the department's Prosperity Division, which includes the Michigan High-Speed Internet Office, Office of Global Michigan, Michigan Women's Commission, Michigan Community Service Commission, My STEM Council, and Black Leadership Advisory Council. She also serves as LEO's Equity and Inclusion Officer. Please welcome Dr. Bell and Kimberly Trent.
Hello, my name is Dr. Donna Bell, and thank you so much, Kimberly, for that wonderful introduction. And thank you to the Michigan Department of Civil Rights for your invitation to talk at today's My Response to Hate virtual campaign forum on behalf of the Governor's Black Leadership Advisory Council on the topic of the Crown Act. To give a little background on the Black Leadership Advisory Council, which is affectionately known as BLAC, it was established in 2020 and has been charged with identifying barriers in the Black community in education, community safety, health, business leadership, immigration, and arts, culture, and communications. BLAC acts as an advisory capacity to the governor to develop, review, and recommend policies and actions designed to eradicate and prevent discrimination and racial inequity for over 1.4 million Black Michiganders. BLAC is charged with accomplishing several goals to help eliminate racial inequities in Michigan, which of one is to identify state laws or gaps in state law that create or perpetuate inequities with the goal of promoting economic growth and wealth equity for the Black community. BLAC's membership includes many professionals in various backgrounds, including economics, law, public safety, health and wellness, arts and culture, and media. And we leverage our experiences and expertise to make recommendations to the governor on critical issues affecting the Black community. We're made up of 16 members, 2 of which are co-chairs, myself and Christopher Bertley, and we have 6 committee chairs. So in 2022, BLAC presented Governor Whitmer with a report that contained 11 policy recommendations based on work that the council had been completing over its time in office. One of the policy recommendations around culture was for the support and legislature surrounding the Crown Act. So creating a respectful and open world for natural hair. And I just want to pause there because that's pretty deep, that we have to have a law that creates a respectful and open world for natural hair. I just want that to resonate. For Black women with natural hairstyles facing bias in job recruitment, for Black children being restricted in schools because their hair is natural and natural styles like braids, our community has been subjected to race-based discrimination and scrutiny on a daily basis. The Crown Act is aimed at eliminating hair discrimination and removes barriers to Black Michiganders achieving economic prosperity. And across the nation, BLAC advocated for this bill by hosting a town hall. We brought in Black community leaders and state legislators to discuss the important topic and to provide guidance to Black Michiganders on the best approach to have their voices heard. Shortly after the town hall, I penned an opinion piece in the Detroit Free Press that spoke to the challenges that Blacks face in our state and across the nation, and why passing the Crown Act into law was so important to all stakeholders. Senator Anthony commended the council in supporting the bill and on our efforts to eradicate discrimination in the workplace. And in June, just before Juneteenth, we celebrated and witnessed alongside Senator Anthony and other legislative constituents the signing of the Crown Act into law by Governor Whitmer. Definitely a time for celebration. So the law provides a path that allows everyone to show up in their place of work, school, or community as their full selves, to give everything they have to the focus at hand. So passing the Crown Act into law in Michigan, it expands the protection of natural and protective styles, and it is the right move for Black Michiganders, businesses, and the entire state. So it's just a benefit for everybody. So to provide you with a few statistics associated with this form of racial oppression, we had a report from Michigan State University, so right here in the state, that did research around the topic. And what they found is that Black women are 2.5 times more likely to be perceived as less professional and competent in the workplace and during job recruitment, and were less likely to be recommended for a job interview because of their hair. In addition, some school dress codes even explicitly prohibited hairstyles that feature one natural hair texture or expression of cultural pride, all which prevents women and children from being their authentic selves. These statistics are mirror those at the national level. So Joy Collective did a research study for girls in 2021, where they provided a number of statistics around the topic of the Crown Act. So the Black Leadership Advisory Council is committed. We are committed to listening to and taking action on critical issues that Black Michiganders face. The Crown Act being signed into law was a success, and we look forward to working toward the successful advancement of other important topics that impact the Black community. With that foundation, I'd like to introduce Kim Trent, Deputy Director for Prosperity for the Michigan Department of Labor and Economic Opportunity, to share her experiences surrounding natural hair. Over to you, Kim.
Thank you so much, Dr. Bell. It is such a pleasure for me to be here tonight to have this really important conversation. I just want to applaud our colleagues at the Michigan Department of Civil Rights for their interest in this topic, and everyone who is on the call to hear about it. The Black Leadership Advisory Council was very pleased to take a leadership role in supporting Senator Sarah Anthony, who introduced this legislation not once, but 3 times. I should tell you that when she introduced it, some of her colleagues mocked it. They thought that it was trivial. They thought that we had other issues that were more important at the time. But what can be more important than an entire race's self-esteem and how they are treated in the workforce? And whether, as Dr. Bell said, they're able to show up as their authentic selves without being judged or punished. We know of cases here in our state where children were sent home from school, or one child actually had her hair cut because it was in its natural state. I have been on a natural hair journey on and off since I was in my 20s. And I can tell you in the 1990s, when I first started wearing my hair natural, I'm sorry to say, I got a lot of pushback, not just from white people, but also from people of color. Since then, we've gone through phases where it's been very popular, where it's been more embraced, and I'm happy to see that. But the bottom line is, if you wear your hair, the way that it grows out of your head, the way that God intended for it to grow out of your head, there's no way that you should be able to be discriminated for that reason. And that is not judging anyone the great thing about Black hair is that it is so diverse and flexible. You can wear your hair straight. You can wear your hair curly. You can wear your hair in Afro puffs. You can wear your hair, you can wear your hair in braids. You can wear your hair in locks. That is a good thing. Having hair that is that able to be worn in so many different styles is a great thing. But certainly being able to wear it the way that it is naturally arranged on your head, it should never, ever be something that we have to fight for, although we did. And we know that there are a lot of misconceptions. There were organizations that said that they were against it because they think that in our natural state, our hair is somehow less kempt or unclean. So a lot of it is just about education. And so we were very happy to be part of that education, working very closely with Senator Sarah Anthony, who was leading on the legislative side. And so happy to see that victory for the Crown Act here in Michigan. The work is not done. We would certainly like to see a federal act, which has been introduced. We know that many states have adopted the Crown Act. We know that just adopting the Crown Act is not always enough, because we saw a case in Texas recently where a student wore his hair in a style that reflected his African-American culture, and he was punished for it, even though Texas does have a Crown Act. So we know that there are many different ways that we protect our rights, certainly in the courts, with laws like the Crown Act, and with having people in enforcement who take it seriously. And so I'm very happy that in our governor, Gretchen Whitmer, we have a governor who has in many ways demonstrated her support for the greatness that is the diversity that we have here in the state of Michigan. And one way that she has demonstrated that is by signing the Crown Act. And it was one of the 11 recommendations that Black introduced in his 2022 report. We will have another report that's coming out in 2024. We encourage you to look forward to that. We'll have that out in midsummer. But in the meantime, we are celebrating victories as we get them. And certainly the Crown Act is a victory, not just for Black people or Black women, but for all Americans, because it is a way for us to say that everyone counts. And that makes America even stronger, and certainly here in Michigan too. So thank you so much for the invitation, Kimberly, for us to talk about how Black has played a role and worked closely to support the Crown Act. And although I will not be able to stay on for the entire presentation, I know that Dr. Bell will, and we are both very grateful for the opportunity.
Thank you very much. I appreciate you being here.
Thank you.
And this is Kimberly speaking. Thank you, Dr. Bell and Kimberly Trent, for your support of this important legislation. Your work demonstrates how grassroots efforts can lead to impactful change. Audience will remind you again that the Q&A chat function is open currently, and you can put any questions that you have there, and we will address them after our last presenter. Next, we have Cameo King. She is a global leader who advocates for girls and women to show up authentic and whole at home, on the job, and in the community. She does this work as the founder and executive director of Grit, Glam, and Guts, GGG, a Lansing-based nonprofit that has national impact. For over 10 years, Cameo has worked with thousands of girls and women with the focus of increasing self-awareness, developing a healthy self-identity, recognizing and engaging the power of their voice. GGG includes multi-city partnerships, a week-long residential camp at Michigan State University, teen conferences, after-school programming, and most recently, Black Girl Day of Play, a day where thousands of Black women and girls across generations, cultures, and socioeconomic statuses come together to celebrate the joy of Black girlhood through play. She is the creator and host of the Good Girl podcast, a national multimedia platform known for uncomfortable truths she calls confessions. Every week, she centers a confession rooted in the experiences of Black women with the goal of deconstructing the notion of good femininity. At the core of everything she does is healing and freedom of women and girls. She absolutely loves being Black, being a woman, and a daughter of Howard University. Welcome, Cameo King.
Thank you so much for that welcome. Again, my name is Cameo King. I have long brown curly hair and a light pink shirt. I am excited to be here, excited to share my story. And I want to put a story to why the Crown Act is so important and how transformational it is for the lives of your neighbors, family members, and community, and specifically me. And see, while you may now know some of my accomplishments as an award-winning journalist or the impact that I have on the lives of girls and women across the state and nation through my nonprofit Grit, Glam, and Guts, I, nor any of us, is immune to the systems that do not consider me for my merit, ingenuity, or skills, but rather judge and even deny me based on a hairstyle. And many folks may consider hair to be a shallow concern, but for me and many of you, it really isn't. It's really about what my hair is connected to, how it impacts my confidence, my ability to gain wealth, my social status, and even my desirability. All things that I thought hard work, determination, and character seemingly would take the lead on. So let me tell you how hair, as it grows out of my head, impacted me. I was fresh out of college, bright-eyed and bushy-tailed, ready to begin my career in journalism, ready to learn, ready to work hard, and even ready for rejection. Because my journalism professors at Howard University prepared us. They prepared us for the job market. They told us to take any job you could get because TV journalism is a difficult business to break into. Because of this, they prepared us well. They told us, first and foremost, you have to be a good writer. You have to be a great writer. That's the thing that will set you apart. So whenever you get the chance, write. Write for TV, write for radio, write for newspapers, write for magazines. And that is exactly what I did all throughout college. I had an internship basically every year and every semester where I was writing and talking, be it local newspapers, radio stations, magazines, any opportunity. So upon graduation, I got my first job as a producer at a then CBS affiliate in Lansing. And I just knew I was on my way. As a producer, I wrote entire newscasts. And I also made it clear to my news director that I wanted to transition to on-air talent. So every week or every other week, I would write and produce news stories in my off time for my news director to review. And he would give me pointers on everything from how I spoke to the cadence in my voice to even ways to improve my writing. And this went on for roughly about 6 months until we had this one particular meeting. He reviewed my TV reel that included writing, video of me on scene, and even live reporting. And he asked about my hair. He said, "You won't get a job in TV with your hair like that." My response, completely confused. I said, "Like what?" He was pointing to my curly hair. He said it was distracting. I said, "Okay," and walked out. My initial thoughts were, well, he isn't the only news director, nor is this the only TV station in Michigan, let alone the United States. So I applied and got an interview in a small town in Ohio. The news director's response there, "What's going on with your hair?" Obviously, I didn't get hired there either. As with all things, I began to question my skill set and think maybe I'm just not that good. Well, you see, I was also working in radio as well at the time. And in radio, I went on to become an award-winning journalist. So it wasn't my skill set, but rather the thing they pointed out, my hair. And I still didn't get hired anywhere. Was I hurt and angry? Yes, definitely. Because how could you deny me an opportunity to pursue a dream that I worked so hard for because of my hair? Who knew small coils that danced across my head would be so powerful to void years of hard work, intentionality, and skill? Well, actually, a lot of people knew, because I know I wasn't the first person to experience discrimination regarding my hair. I know there are countless men, women, and children who have come before me that have lost jobs, promotions, status, and even educational opportunities. A turning point for me in my story was a question that my mother asked. She said, or maybe a statement that she said, "You have to decide what's most important to you. Is it your hair or is it this job?" And in that moment, I understood within myself, it really wasn't about my hair specifically, but that statement that I led with, that it was about what my hair was connected to. It was connected to my confidence. It was connected to my ability to gain wealth, my health, my desirability. It was connected to all those things, my pride, my Blackness, and it is today. I am proud I made that decision and have always been at peace about that decision. And I believe it comes full circle as the founder and the executive director of Grit, Glam, and Guts, or GGG, a nonprofit that empowers teen girls and young women to be the best that they can be, to be their authentic selves. Because our authenticity is connected to our self-actualization. It's rooted in who we are. It is the center of our joy. And I don't know if I could stand before the girls that I see week in and week out, or if I could stand before crowds of people and know that I, at one point in my life, did not stand in my authenticity, that thing that gives us peace, that thing that gives us joy. And so I share my story to put a face, a name, an experience to why the Crown Act is so important. Thank you.
Thank you so much, Camille, for sharing your riveting personal journey. We appreciate you allowing your light to shine, which gives others permission to do the same. Next, we have our presenter. Her name is Chandrika N. Simmons. She is a solo practitioner and mediator at lawchic.com. Her Michigan civil litigation practice focuses on labor and employment, family and contractual law, probate, and real estate. She has been in the legal field for over 24 years, a former union advocate and former union president of the American Federation of State and County Municipal Employees, Local 3309, Third Circuit Court. She now engages in litigation against employers, unions, school districts, and municipalities for civil rights violations while handling high-risk divorce, involving allegations of abuse. She is everything contracts from sports, death to real estate. She is a serial entrepreneur, with her latest venture being a supervised parenting time facility in Oakland County and Wayne County, while also offering mediation services based on income levels. She is married to a master barber and co-owns their hair salon, Universal Hair Design. She is the mother of 3 biological daughters and 6 non-biological children that call her mom. She is a Black woman who understands that hair to us is as important as bathing daily. She is an advocate for those that cannot be authentic to themselves in a world built on white supremacy. She is the voice of the voiceless. Welcome, Chandrika N. Simmons.
Thank you so much, Kimberly, for that great introduction. And I appreciate the invitation as well from the committee and the governor to speak today. Kimberly Trent spoke about briefly about an incident of a little girl here in Michigan whose hair was cut while she was at school. Well, that's my case. That was a case that I filed in federal court for a biracial child who identifies as Black, whose teacher and librarian decided without permission and notice to cut that child's hair at school. The results of that were damages to her self-esteem, damages to her actual hair and how it grows and the rate it grows and her curl pattern. I know that Black women and how we do our hair every day and address our hair every day is at the forefront of how we function every day, and how this child was negatively impacted because there just wasn't any cultural awareness of how we are connected to our hair. Our hair dictates every aspect of our lives, unlike any other person identifying as a woman. From showering versus taking a bath, versus having a hotel room with a shower versus a hotel room with a tub, vacations that involve water or without water, engaging in sports, exercise, intimacy, and being on time for events. All of these things, our hair is at the forefront of a decision we're going to ultimately make of how we're going to engage and move. Hair impacts how we socialize as well as interact, from accepting invitations that fall on wash day. People don't know that we have a wash day, that we set aside a day to actually take care of our hair, because it is not a quick and swift process for many of us. How an invite can impact a braid appointment that we have that we couldn't get, and and you just can't walk in. So you've had this standing appointment for years or months. And so someone invites you to something on that same day, that impacts your ability to go because you can't miss your braid appointment. Or having a hair appointment that you can't miss, as well as going out to events and making a decision if you're having what we deem a bad hair day, where your hair is just not being cooperative, and therefore you don't want to go outside and you don't want to present yourself. That has an impact on how we move and groove in social society. And I believe that because people are not culturally aware of what it is that we're going through, that they make assumptions that it's not that big of a deal in regards to hair, that they make assumption that they can tell us what to do with our hair. When we say don't touch our hair, we mean it, because it takes a lot to get where we are. And it's disrespectful on so many levels, because our hair is our crown. Our hair is part of our DNA. It's how we present ourselves to the world. It's how we speak sometimes in our dress. As I'm presenting today, I have, for those of you who cannot see, I have on a black blazer with no sleeves and a cream rose long sleeve shirt, and I have my hair braided up into an actual bun that looks like a crown. This is part of how I'm presenting today. I made a conscious effort to schedule me a braid appointment for today. To be ready for today, to make sure that my aesthetic matches perfectly for today, so that I can be presentable how I feel I should be presented in this forum here today. And what this Crown Act does is allow us as Black women to have freedom, Black women, Black children, and Black men and boys to have freedom to be who we actually are, to be our authentic selves, whether that shows up in braids, whether that shows up in locks, whether that shows up with a bald head, whether that shows up with a fade, whether that shows up with I shave one side of my head, because that's how I was feeling that day. It's my hair, and I should not be discriminated against based on how I'm interacting and dealing, because a lot of times it is a deal. We're asking God, please let this be a good hair day today. We're asking our hair, please cooperate with me today. So how I'm dealing with my hair should not be of concern to others. If I deem it to be professional and it's combed as far as I'm concerned, that should be of no concern to others. And I think the fact that Michigan, being a trailblazer in this arena of passing the Crown Act, has set a tone, and I'm hopeful that going forward, we won't have as many cases as we have seen in the past of issues with how others perceive our hair and how it should be presented, whether it's in the schoolhouse or in the courtroom or in corporate America, that we are allowed to be our authentic selves and walk in that authenticity without regard.
Thank you so much. I appreciate you sharing with us this evening. And our final speaker this evening is Bryant Kosowitz. Bryant is recently appointed the Director of the Office of Legal Affairs for the Enforcement Division of the Department of Civil Rights. There he manages the staff attorneys who litigate civil rights violations, advise the civil rights investigators. Prior to his appointment, Bryant worked for the Department of Attorney General, rising from a line attorney to acting chief of the Criminal Justice Bureau. As an assistant attorney general, Bryant investigated and prosecuted matters such as the Flint water crisis. As an acting chief, he supervised the department's criminal divisions and the special units, such as the Hate Crimes and Domestic Terrorist Unit. Before joining the Department of Attorney General, Bryant was an assistant prosecuting attorney in Oakland County. A lifelong Michigander, he currently resides in Oakland County with his wife and 3 children. Please welcome Bryant.
Thank you for having me. As Kim mentioned, I'm the Director of the Office of Legal Affairs for the Michigan Department of Civil Rights. I'm here to talk about a little more nuts and bolts about the Crown Act. The importance of enacting the Crown Act, I can't top the previous speakers with their experiences and what they know about why it was important, but I'll try to add to that. One thing unique about Michigan is civil rights are enshrined in our state constitution. Article 5, Section 29 of our Constitution created the Michigan Civil Rights Commission, whose job it was to enforce civil rights in the state of Michigan. In particular, it states, "It shall be the duty of the commission in a manner which may be prescribed by law to investigate alleged discrimination against any person because of religion, race, color, or national origin in the enjoyment of the civil rights guaranteed by law and by this Constitution, and to secure the equal protection of such civil rights without such discrimination." So that is part of our Constitution and prescribed by law. As a result of that, the Elliott Larson Civil Rights Act was enacted. It's Public Act 453 of 1976. That gives my department, the Department of Civil Rights, the power to investigate, the power to enforce the civil rights statute, and to ensure that all Michiganders can enjoy their civil rights. Now, in particular, the Elliott Larson Civil Rights Act enforces civil rights in particular areas of civil life. It's a series of articles. Article 2, for example, employment. It also includes education, public accommodation, so places open to the public, such as a retail store, public service, so state and local government, as well as housing. It protects against discrimination for particular protected bases. Now, within the Constitution, it listed religion, race, color, and national origin. The Elliott Larson Civil Rights Act over the years has expanded. So the protected bases, what we call, now includes religion, race, color, national origin, age, sex, sexual orientation, gender identity or expression, height, weight, familial status, or marital status. Now, all these protected bases don't necessarily apply to each area, such as employment or public accommodations, but race applies to all of them. However, although race applies to all of them, race is not specifically defined within the Elliott Larson Civil Rights Act, and it did not account for traits historically associated with race, such as protective hairstyles like we're talking about today. Dove had a series, I think it was alluded to by Dr. Bell. Dove had a series of studies that they have done throughout the years to highlight the discrimination and bias that occurs with these protective hairstyles. In 2019, they did a research study for women and have found that there was workplace bias against hairstyles that unfairly targeted Black women, and it unfairly impacted their ability to celebrate, I think has been mentioned, their authenticity, their natural hair. That particular research study found that they were 1.5 times more likely to be sent home from work because of their hair, 30% more likely to be made aware of a formal workplace appearance policy, 80% more likely to change their natural hair to meet social norms or expectations at work, 83% more likely to report being judged more harshly on their looks than other women. Now, that had to do with workplaces, but it didn't stop there. In 2021, Dove did another research study for girls, and it found that formal school policies that ban hairstyles inherent to Black culture, that unfairly targeted Black children. That particular study found 53% of Black mothers said their daughters experienced racial discrimination based on their hairstyle as early as 5 years old. 66% of Black children in majority white schools faced race-based hair discrimination, and 86% of those children had experienced it by the age of 12. 90% of Black children were stated that their hair is beautiful, but 81% of Black children in majority white schools say they sometimes wish their hair was straight. And as a part of this study, it said 100% of Black elementary school girls in majority white schools who reported experiencing hair discrimination experienced discrimination by the age of 10. Now, there was another more recent study in 2023, a workplace research study by Dove. It surveyed approximately 3,000 female identified respondents in the US from age 25 to 64, roughly equivalent of 1,000 Black people. 1,000 Hispanic people, and 1,000 white people. And that particular study found that Black women's hair is 2.5 times more likely to be perceived as unprofessional. 2/3 of Black women changed their hair for an interview. Black women were 54% more likely to feel like they had to wear their hair straight for a job interview to be successful. And over 20% of Black women ages 25 to 34 were sent home from work because of their hair. 44% of Black women under 34 felt pressured to have a headshot with straight hair. And 25% of Black women believed that they had been denied a job interview because of their hair. Beyond those facts from those particular studies, you had news stories and anecdotal evidence of hair discrimination. As Ms. Simmons mentioned, her case about the 7-year-old whose hair was forcibly cut in school, alluded to by Ms. Trent as well, without the permission of her parents. There was another in August of 2018, 11-year-old Black girl was sent home from a private school in Louisiana because she broke a rule. She was wearing braids and had hair extensions. Bottom line from all these stories, these facts, these stories, these type of hair discrimination makes people feel less than who they are. And that's unacceptable. That's unacceptable in Michigan. So as a result, as mentioned by Dr. Bell, State Senator Sarah Anthony introduced, apparently for the 3rd time, Senate Bill 90 in 2023 to codify the Crown Act into the Elliott Larson Civil Rights Act. A committee hearing was held at the Committee of Civil Rights, Judiciary, and Public Safety on May 4th, 2023. And many people submitted their support for this bill. One of those was Gabriel Dresner, a policy strategist from the ACLU of Michigan, who submitted a letter in support, and it articulates why it's important. She wrote, an individual's hair has absolutely no impact on their ability to do their job or to learn in school, but racial discrimination certainly does. It is long past time that we recognize that race and racism create situations that are far more complicated than the current statutes provide for. This bill would help protect Black Michiganders who deserve to live and work in their state without fear of discrimination. False and racially exclusionary beliefs about what professional hairstyles entail have long been used to discriminate against Black women and girls. This important legislation will make explicit in our state civil rights law that hair discrimination is racial discrimination and it is illegal. The ACLU of Michigan supports this bill and encourages you to vote yes. And there were many other statements of support for the bill. So Senate Bill 90 was introduced in February 2023, and it was ultimately passed and signed by the governor with immediate effect in June 15th, 2023. So what was the actual bill? What did it actually do to the Elliott Larson Civil Rights Statute? Put the slide up, please. It added a definition of race. Now, remember I said it was not defined, it was the common definition, but now it modified Michigan Compiled Law 37.2103 to include a definition of race, which reads, race is inclusive of traits historically associated with race, including, but not limited to, hair texture and protective hairstyles. And for purposes of this definition, protective hairstyles includes, but is not limited to, such hairstyles as braids, locks, and twists. That's what it did. That's all it did. It was a pretty simple legislation to ensure that the definition of race, there was no question about what it included, and it included those traits historically associated with race, such as those protective hairstyles. I'll put that down, please. And it was included in Article 1 of the Elliott Larson Civil Rights Act, so it applies to all articles. So that definition of race will apply to employment, it applies to public accommodation, public service, education, and housing. Now, Michigan is now one of 23 states that have Crown Act legislation. And because it's not necessarily a complicated amendment to the Elliott Larson Civil Rights Act, implementation so far has been pretty easy. All we had to do was make our staff aware of this legislation. Race is already a protected class, so it's just a matter of recognizing the issue and drafting language of our complaints to conform with that statute. Now, by law, when somebody makes a complaint to the Michigan Department of Civil Rights, if we have jurisdiction, we take the complaint. There's no comment on the legitimacy of the complaint or whether or not we'll be able to substantiate that complaint. So to establish jurisdiction over the complaint, we have to establish that protected class, which obviously we're talking here about race. We have to establish the proper relationship, and that has to do with the articles I just talked about. So is it an employment case, a housing case, public service, public accommodation, or education case? Now, we are a law enforcement agency. We administratively enforce the civil rights statute, so we have rules. And we do have a statute of limitations. Now, to be clear, the Elliott-Larsen Civil Rights Act does have a private cause of action, so people can sue in court for violations of the Elliott-Larsen Civil Rights Act. And that statute of limitations, I believe, is 3 years. But for our administrative investigation and enforcement process, someone has to make a complaint within 180 days of what we call the adverse action. Now, the adverse action can change depending on what the area of law the complaint is brought under. So for employment, adverse actions can include failure or refusal to hire or recruit, being discharged for a discriminatory reason, being disciplined or demoted, being failed to being promoted or transferred, creating a hostile environment due to someone's protected class, or being subject to other terms and conditions that other employees not members of that protected class are subjected to. For a public accommodation or public service, certain adverse actions can be denied access to the public accommodation, can be denied service by the state and local government, can be unequal service, you can be treated differently because of your protected class in a public accommodation or public service. And with regard to law enforcement, it can include racial profiling. Under education, adverse actions can be lack or refusal to admit or to register a student, discipline due to a protected class status, including grading, being subject to other terms and conditions other students aren't subject to because of your protected class, or being subject to a hostile environment due to your protected class. And in housing, some adverse actions can include refusal to rent or sell due to somebody's protected class, refusal to deal other terms and conditions, being subject to other terms and conditions due to your protected class, a refusal to renew a lease, being evicted because of a protected class, falsely representing availability. It also includes a hostile environment due to your protected class. So once we establish these adverse actions that were taken due to somebody's protected class, then we could take that complaint and investigate that complaint and try to substantiate that complaint. Clear, we're a neutral party. We're not representing what we call the claimants, the person making the complaint. We're not advocating on behalf of the respondent, the person, the complaints, who the entity the complaint's made against. We are a neutral fact finder to try to enforce the civil rights statutes and to ensure that everybody enjoys their civil rights. Now, this was a recently passed statute. So to date, we've actually had at the Michigan Department of Civil Rights, there's been cases out there, we've had no complaints that have been in violation of the Crown Act yet. I expect that to change at some point, but to date we haven't had it. And my research into what's been out there nationally, I haven't found any housing cases necessarily. And I haven't found any public accommodation and public service cases. Doesn't mean they're not out there. They haven't been necessarily litigated, but what has been focused and what I think the previous speakers have alluded to is I think most of these cases come from employment, they come from education. Somewhat recently in California, a man filed a complaint against an employer for a violation of California's Crown Act. He worked for a company, he relocated to San Diego. After the pandemic, he tried to apply to that same company who had a presence in San Diego. He interviewed with that company. At the interview, he indicated, or the person indicated he was qualified for the job. He had worked for the company before, he knew what he was doing, but he would have to comply with the grooming policy. And so he'd be forced to cut his hair. So he was not hired. He refused to do it. He was not hired. He made a complaint. He filed suit under California's Crown Act. That case was eventually settled. And I suspect that nationally, the states that have the Crown Act, especially when it comes to employment cases, people that file complaints, these cases are settled, so you don't necessarily see them in the courts. So I think there's more employment cases out there that are in violation of the Crown Act. We just don't know about them. But as what has been alluded to before, I think the other big one is education. We see a lot that before Crown Acts were passed, you see the news stories. I don't know if people recall in 2018, a wrestler in New Jersey, a student, a referee forced him to cut his locks before a wrestling match or he'd be disqualified. I don't know if they had the Crown Act at the time, but news reports indicate that a referee was not going to be refereeing any wrestling matches any further. In 2018, a student at BYU in Utah had to seek a exception for BYU's grooming policy in order to keep his protective hairstyle. But it was an exception, it wasn't just that. And as I think, I don't know who alluded to it before, I don't know if it was Ms. Trent or Dr. Bell, there's a case out in Texas that just came down. A male student who had a protective hairstyle, had locks, was being disciplined because he refused to cut his hair. He refused to conform to the grooming policy of that particular school. Now, just recently, the judge in that case, it's a state law case, even though Texas has a Crown Act, found for the school district. And though Texas, their Crown Act is similar to ours, that particular judge, from what I can tell, focused that because it spoke about hair length and not texture or protective styles, that it was facially neutral and did not violate the Crown Act. So for the time being, that was okay, but that case is not over. I expect it to be appealed, and I don't know if we'll have any similar type cases in Michigan, but I do not think that, I don't think that would stand in Michigan. I'll just say that. And it's not going away. I think it keeps going. Specification article, just was it 2 weeks ago, on March 19th, another BYU student, BYU Hawaii, was approached by a security guard, a BYU security guard, who asked for his ID and indicated that his hair did not conform with BYU's grooming policy. That just was obviously reported, so we'll see if that goes anywhere, but it's out there, and I think it's most of the cases that are going to be brought have to do with policies, either employment or education, school policies that have a disparate impact on Black people or other folks who have protective hairstyles, or straight discrimination, hostile environment, people discriminating against people for their protective hairstyle. So in conclusion, I know the amendment to ELCRA will not just provide a mechanism for us to enforce the state civil rights laws and to ensure that hair discrimination doesn't take place in Michigan, but I hope it will have a deterrent effect, that employers, schools will be aware of this legislation and not enact policies or enforce policies that discriminate against people or have a disparate impact against minority groups. But beyond that, as I think what part of the purpose of this seminar is, or this presentation is, through education, through these presentations, we need to combat that perception that these protected hairstyles are somehow unprofessional or otherwise somehow improper. And we need to challenge these outdated societal norms that certain traits like these protected hairstyles, they have nothing to do with someone's ability to do a job, to receive an education. So thank you for listening to me. And if anybody listening has a complaint of discrimination or believe they've been discriminated against because of their protected hairstyle, please contact the Michigan Department of Civil Rights. And I'll be available for questions later. Thank you for your time.
Thank you, Brian Oskowitz. I appreciate it. I'm sorry. for sharing the important information that will ensure Michiganders' civil rights are protected concerning issues of hair. I will ask all the panelists to please restore your video as we begin our Q&A. Audience, feel free to put your questions in the chat area, and we want to honor and respect your time, so we will address as many questions as we can in the allotted time. So I will go to our moderator of the chat. If you could read our first question.
This is Todd speaking. Our first question is, do you have any recommendations or resources for how food service organizations can provide inclusive hair covering options for employees with natural or extension hairstyles while still following food safety standards where hair is covered and restrained and meeting uniform guidelines? I think Ms. Simmons can speak to that.
Yes, this is Attorney Simmons. So I answered the question in the chat, and I'll just repeat it, because according to the FDA food code, hair restraints like hair nets, baseball caps, or hats are acceptable wear. So sometimes you'll see people in the kitchen having a baseball hat on that are cooking, and that is acceptable. As long as it's keeping the hair off the face and away from the food, it's acceptable hair, according to code. I would also like to say that because of respectability politics, people have some issues sometimes with bonnets and the displaying of bonnets in public spaces. You got to let that go. A traditional chef hat is just that, a bonnet. If you think, just roll it back in your head and you think about it, it's a bonnet. It's just white. So if you allow your workers to wear bonnets, to keep their hair off their face and keep it away from the food, that's acceptable. If you allow them to wear, I have one child with locks, she wears a lock sock. So that's basically, it's a tight head covering that keeps her locks intact and away from her face and makes them not so heavy sometimes on her, release some of that weight. Also, their head wraps, just a lot of people, especially in courts, we've had this issue before in local courts. I'm a former president of the Black Women Lawyers Association, and we had some issues with judges who didn't want our Black women attorneys to wear head wraps to court because they think that if it's not part of your religion, you're not Muslim or some religion that requires that you should just comb your hair. Head wraps are acceptable. And you should be able to wear a head wrap because the ultimate goal is to just keep the hair out of the food. So if we just focus on the ultimate goal and not focus on what you think it should look like or what you feel it should look like, if the goal is to keep the hair out of the food, then make that the goal.
Thank you. Has the Civil Rights Department had the opportunity to review the employee training the state is currently offering on the Crown Act? I've taken the training, and in my opinion, it doesn't go into enough detail as to what constitutes discrimination based on how we wear our hair. Kimberly, do you want to answer that?
I will defer to our legal, Brian.
No, I don't know what particular agency you're referring to, if there's a statewide training or if a particular agency was offering training on that. So if you want to put in the chat or follow up about exactly what training you were referring to, we can follow up on that.
Thank you. Are there protections for students who are training in clinical environments regarding hair discrimination, i.e. hair extensions or hair color? There are a number of clinical facilities with expectations of hair for the dress code.
I can try to answer that again. It'll be on the employer, or I don't know if the clinical, if you were talking about an employer, it'll be on the employer to articulate the reason they need to have to essentially discriminate. I know in our rules, our statute, and employers can ask for exceptions to the rule if there's a particular reason they need to have a policy that may have a disparate discriminatory effect on a particular class of people. So it'll be on them to justify why they need to have that policy.
Thank you. Does this law apply to men also with braids?
Yes. And to be clear, no, I think the impetus for this legislation was Black women, of course, but the way it's written, it does not specify it has to be Black women. It can be Black men. It could be indigenous people as well. So anybody with a protective hairstyle, cultural hairstyle, are protected under the statute.
We have another question. I believe we've touched on this. Do you think it would be unreasonable to require employees whose hairstyles does not fit under the uniform cap to provide their own hair covering that meets specific criteria, such as specific color, even though other employees receive a uniform cap as part of their uniform free of charge? Or should the food service operation be expected to provide an alternative covering for the employee, although it may not be exactly what the individual wants to wear?
So Brian, can you share with us what type of exceptions or workarounds or alternatives an employer in a food service space could utilize with regards to their hair covering policy, yet keeps them compliant?
Well, that presumes one thing, that presumes that they're doing it to be compliant with food safety regulations. And I don't know if that's the case here. I mean, if we're talking about a specific case here, if it's more of a uniform policy, if a more aesthetic thing as opposed to a safety thing, I mean, we're getting to a specific case here in the sense of if you think you're being discriminated against because of your hair, I mean, how to articulate this? It's a lot of these violations would be fact specific. So in my opinion, I think if you have a concern that you're being discriminated against, you know, you can file a complaint with the department and it can be investigated. But in general, the idea that they should be forced to purchase their own head covering to be compliant with the uniform policy, that could fall under what I mentioned before as an adverse action, other terms and conditions, as in some employees are expected to do something that other employees not of the protected class are not required to do. So that could be a violation, but again, it's very fact specific. So if you feel you're being discriminated against, you can contact the department and we can look at it.
Thank you. What should schools, employers, and businesses include in the hygiene or dress code policies?
And so I think that question comes from, this is Kim speaking, just the way that employers who want to be proactive can, again, start to look at their policies that are already in place to be compliant with the law. So if their dress code policy has certain language, what can they do to ensure that the Crown Act is not being violated based on what they are requiring?
This is Attorney Simmons speaking. I think that being a labor and employment lawyer and a former union lawyer, who I've written several collective bargaining agreements from scratch, as well as consulted with employers on policy. If we don't get past the language of professional and trying to deem what professional means from your own personal experience perspective, then if your policy is reading as such, you might want to reevaluate your policy. because what you deem professional and what someone else deemed professional could be two different things. And so when you think it's blanket language, or you just come professional, or like we say sometimes casual Fridays, well, casual to somebody in Florida may be different than casual to somebody in Rhode Island. And so there are different nuances to it. What I would advise is, given that we have the Crown Act now, you consult with an attorney and someone who writes policies and procedures for employers to get a robust and revamp your entire stance on what you deem professional, and the use of the word professional as it relates to your policy procedure. As someone who employs several people, and I don't want to be sued because I sue people and I know how that feels. I tell people that I hire, if you think it's cute, then wear it. If you presenting your best self today, and that's how you're going to produce work for me, then that's how you coming. And I'm cool with that. But everybody may not be. But I don't want any problems with how, I want you to look this way, tattoos, no this and this, don't do all the, it just creates so many different layers of problems that you don't need. It's the work product being produced. That's the bottom line. Is the person performing up to your standards? That's the bottom line that you should be looking at it, versus how is this being presented and how are people perceiving this to be? I think we're slowly moving away from it, but it's really slow moving away from how you feel like somebody is perceiving this person who's working for you.
I agree. If I could just add on to that real quick. And as I mentioned before, I hope that this legislation will change the perception, not just about professional, but the question indicated as well, hygienic. I mean, beyond food service and stuff like that would have specific rules. This idea that certain protected hairstyles are somehow unhygienic, we got to get away from as well. So I would agree with Ms. Simmons that consult an attorney regarding the policy, but hopefully the perception, the optics will change as people become more aware of the Crown Act. Thank you.
Thank you. If someone feels like they have been discriminated against because of their hair, what should they do?
This is Kimberly. So I would encourage anyone to file a complaint with the Michigan Department of Civil Rights. We are here. That is our objective to, again, we are an enforcement agency. So we want to make sure that Elliott Larson is the law of Michigan and that it is enforced. So if you believe you have been a victim, feel free to reach out to us at michigan.gov/MDCR. You can find information there as to how to file a complaint. And then we can have our investigators and staff help walk you through how to file a complaint and what you can expect from that complaint process. Also, you also have the ability to file a lawsuit as well, if you so desire. And I think I'll shoot it back over to Bryant. He spoke about our time frame. So if you would uplift that again.
Yes, before we can take a complaint, what we call a certified complaint for our administrative enforcement process, we have to establish jurisdiction, and our rules state that we can only take complaints that occurred within 180 days of the adverse action. Now, if it's beyond that, it doesn't mean it's gone. It means you'd have to file a civil lawsuit, and I believe the statute of limitations for that is 3 years. So that should be in somebody's mind before they file a complaint as well.
Does the Crown Act protect residents and visitors from their hair being searched by the police and or TSA encounters?
This Bryant, I don't think so. I mean, if they were targeted or if they were profiled because of their hair or because of their race, that's a thing. But, and I'm talking specifically to the Elliott Larson Civil Rights Act. If we're talking about 1983 actions or something, we don't have jurisdiction over that, so I can't speak to that. But not necessarily unless there was some other discriminatory reason that they were searched. I don't know, Ms. Simmons, if you have any other thoughts on that.
My sentiments exactly as far as TSA in the search. There are elements that go into that. If they're searching you for the pretense of that's because you're looking a certain way, because your hair is looking a certain way, that could be different levels of discrimination. Could be based on religion, it could be based on race, it could be based on a whole myriad of issues. So if the question is, can they do the, is it part of the Crown Act discrimination part of that? I don't know. I don't think that it is, but it could be different layers to it, if that makes sense.
Okay. In the case in Texas, the court stated that the school district could keep the student out of the school based on the length of his hair locks. Do you anticipate more legal battles concerning the Crown Act? And what should the Crown Act legislation include to prevent this type of ruling in the future?
Yes, I expect, this is Brian speaking. Yes, I expect more litigation regarding that. And I honestly think it'll depend on the forum, it'll depend on the venue about how it'll be ruled on. As I mentioned before, I don't know if Michigan would rule like that because the legislation didn't specifically address length as a part of the protection. I know that the school's policy in this particular case indicated that even if you wear your hair up, if its length when let down goes below a certain, it's not allowed. So I think I mean, if you want to address it in the legislation, include length, it's irrespective of length or something like that. But I still think that was a narrow interpretation by this particular judge in this particular court. I don't think other judges in other courts and other jurisdictions would make the same ruling.
Thank you. How does or will this apply to law enforcement officers such as Michigan State Police?
As I mentioned before too, employers can ask for essentially exceptions to the rule, and law enforcement is a big one. I mean, they're essentially a paramilitary organization, law enforcement agencies, so they are not subject to certain rules. Like, for example, misdemeanor arrests are protected in certain instances under the Elliott Larson Civil Rights Act, but that doesn't apply to law enforcement agencies. So certain industries, certain employers can have exceptions, can ask for exceptions, and I think law enforcement will be one of those exceptions because of its nature and because it's kind of essentially a paramilitary organization. So I don't think that they'll necessarily have to comply with the Crown Act.
But we have one more question. So hair color like neon green or pink can be a violation that someone would have to address. I'm not sure I totally understand that question.
I think I get it. And Ms. Simmons can offer her opinion as well, but I think we're talking about hairstyles that are, like the term, authentic, that are inherent in their identity, their racial identity. I don't know if circumstances, there could be, but I don't know if circumstances where hair dye, bright green or neon, is part of their racial identity to be included in that definition.
I thought it was an incomplete thought. However, in regards to color, there can be some issues as to deem what is an acceptable color and things like that. Little nuances in the law, and I'm waiting to see, because I thought about it when the Crown Act first got passed, like what's going to happen in regards to the color issue, because it's always been an issue for employers not wanting certain colors and people in their employees' hair and things like that. We get calls all the time regarding, I want to wear my hair this color, they won't allow me. They're saying it's not part of my, doesn't grow out like that color, so I can't have it. I'm curious to see what's going to happen now with the Crown Act and these people having issues with hair color on a job, and see how that plays out. But I did want to address the issue, the question before regarding law enforcement officers and Michigan State Police. I'm a military kid, so I grew up on several military bases in my life. And I just recently noticed that the United States military has changed drastically its policy regarding to hair. And so when someone is looking at how a policy is being applied across the board, so if you have a white woman counterpart who has long hair and she's a police officer and she's able to put her hair in a bun, and I have locks or braids, and you say I can't have that, it's out of regulation. If I'm able to put my hair in a bun too and it not sit on my collar, just like hers doesn't sit on her collar, then there might be some issues there you want to address and bring those to the attention of your employer, that it could be possible discrimination. Because I'm looking at cases like that currently, where if my white counterpart can do this, this, and that, and I can do the same with whatever hair that I have, then what is the difference then? Other than you don't like how it looks. Because if I can put it in the bun, if I can wrap it around and keep it off my shoulders, if that's a requirement, if it can't touch my collar, if that's a requirement, if I can do all those things, then it seems to me like the underlying issue is not my hair itself, but you have an issue with not my hair and length and things like that, but you have an issue with my hair itself. And again, that's how the Crown Act was deemed to protect us from being discriminated against for those reasons.
Thank you, Ms. Simmons.
Rodney, thank you everyone for being here with us tonight. As we come to a close, I want to share our My Response to Hate pledge. Why take the pledge? Michigan residents and visitors have a right to work, play, and live in a safe, welcoming, and affirming environment that values the diverse attributes of all individuals, regardless of race, religion, sex, age, disability, national origin, and all protected bases. Everyone has a responsibility to prevent hate in our state. If we stand together, we can change our communities into places that reflect love, not hate. Join us in making an affirmative stand that will make our state a positive place for everyone. We are all, a positive place for everyone where we are all respected. The pledge reads, I will treat others with respect and dignity. I will speak out against racism and other forms of hate. I believe one person can make a difference. My response to hate is love. Reciting the pledge is a way to demonstrate your commitment to a hate-free Michigan. I encourage each of you to publicly share the pledge on your social media platforms using the hashtag #MyResponseToHate or #MyResponseIsLove. The pledge has been placed in the chat for your convenience. Lastly, I would like to extend a major thanks to all of our panelists. Your expertise and insights have been invaluable. I would also like to thank all of our registered participants who joined us for today's session. We welcome you to join us at our next forum scheduled for Thursday, April 25 from 1 to 3 p.m. The forum is going to be discussing understanding disability discrimination. To find the registration information, you may go to the Michigan Department of Civil Rights webpage. We hope to see you next month. Remember, eliminating hate and bias in our state is all of our responsibility. Thank you again for joining us. Have a good night.